Hey guys, and welcome to this hastily assembled stream. So I have the Attorney General's brief in this case, the Delphi case, Richard Allen, defendant, suspect, felony murder charges, Libby and Abby. And of course, there's been a procedural disaster going on in that case. So I have the AG's brief open, not being shown right now, and also Judge Gull's response. All right, so I'm going to go over those, hopefully both of them, but I want to show something else first. And that is the case I have on the screen because it's referenced in both their briefs. And I think it's interesting both for what the AG and the judge try to use it for, but also for other things that it says. When you read these briefs, it's hard to tell the legal merit of them without researching the cases. And I haven't even read these other than glancing at the AG and pulling up this case. So it's hard to say, but this one I think is interesting. Let's make it a little bigger so you can see it while I go through it. So this went up to the Indiana Supreme Court for writ of mandamus for counsel who were removed in a criminal case by the judge, sua sponte, and what happened. All right, so this was a real winner here, charged with heinous crimes. And a week before his trial was to start, his attorneys moved to exclude state's DNA evidence, or at least provide a continuance. The judge tried to split the baby by not giving a continuance. I mean, this thing was up on the docket, but excluding some of the DNA and then preventing some of the rest of it from being discussed in trial for a period of time to allow the defense expert to evaluate it. But the defense counsel did not like that. So instead, on the eve of trial, they filed a motion to reconsider or in the alternative to withdraw as counsel. And they began their motion as a mock letter to Jones, their client, which says, if you're convicted, it'll be without the benefit of effective representation, due process, or other protections of the U.S. and Indiana Constitution. Have a nice day. That's the start of their motion to the judge. Then the motion criticized the trial court's order in detail, saying that it had irrelevant background information, neglected information, and conveniently neglected other evidence, was misleading. The judge's order plays games with semantics, conveniently omits a crucial fact, and tramples on his rights, and arbitrarily extends the discovery deadline. So these people started a war with the judge. And as I always caution, that's something you need to be careful about. You don't have free reign to do whatever you want just because you're an attorney in the case, and just because the defendant has rights is not licensed to do any and everything you want. So anyway, they also said in this, crucially, if the court fails to provide the relief sought, counsel for the defendant each request leave to withdraw their respective appearances as counsel in this case. So there are some similarities to this case so far, but not many, right? But still, the main thing, as you're about to see, is what happened. The trial court reconsidered its earlier ruling and granted the continuance and denied the request to withdraw, instead sua sponte, removing the attorneys from the case because of the insulting and absolutely improper remarks about the court in their motion to reconsider. The court appointed 2 new attorneys to represent the defendant and to turn over the case files. So this case, of course, got delayed. And then the judge also referred these attorneys to the disciplinary commission. So I'll check in with you guys in a minute on where you're from, but I get through this case so we can get into it, because this is material, I think. First, it shows how the Indiana Supreme Court approaches a writ of mandamus for removal of counsel, and it is cited as authority, as you'll see. So the defendant seeks a writ of prohibition and mandamus from this court to reinstate his defense attorneys. Now that's where we get some similarity to the current case. He argues the trial court was without authority to remove his attorneys in such circumstances. And if they did something wrong, the remedies available were contempt and referral to the disciplinary commission, but not removal of counsel. And there are certainly a lot of people who think the judge can't do that. But there's a difference between from case to case, that you do not have a completely unfettered right to counsel, especially when counsel is appointed. There are balancing situations, and it's not a license for attorneys to do any and everything they want. Again, I'm not comparing their behavior here to the Allen case, pointing out that there are limits. So let's see what this court said. The court has met in conference and reviewed and discussed the positions of Jones, the trial court judge, and the state. So now let's compare that to the current case. The briefs are in, and although Allen's team may request the ability to respond to what the judge and AG said, if that happens, it'll, move things out a week. But if it doesn't, you're still going to get the same result probably, which is the court will meet and talk about this, because that's what they did in this case. And that makes sense. Again, this is on a mandamus action. Notice they said they met and reviewed and discussed the positions. They did not say we will not consider this writ of mandamus. They did not say you have to wait to an appeal. And that's a position that the AG and the judge will make, as you'll see in the briefs. So I think from this authority that they cite, implied in this is that you can have a mandamus action like this considered. It's not a direct holding, I don't think. Let's get through this case. Now, the Supreme Court of Indiana says it's generally of the view that a trial court is limited in its authority to remove a criminal defendant's court-appointed counsel. It'd be nice to know what those limits are, and I think we may be finding out soon. But the court finds it unnecessary to explicate the parameters of that authority here. This is because these attorneys affirmatively requested that they be allowed to withdraw as Jones' counsel if the relief they sought was not provided. We recognize the trial court did not grant their request, but instead removed them sua sponte. Now, obviously, you can see where the state and the judge are going to go with this. These guys wanted to withdraw in the Allen case. But having indicated their desire to withdraw from the proceedings, if not conducted in the way they favored, we will not countermand the trial court's ruling that placed them in precisely the position their motion indicated their willingness to be. We view our ruling as being but a slight variation of the longstanding principle that where a party voluntarily adopts a certain form of procedure or agrees to the manner in which its rights are submitted for determination, the party will not be permitted to complain on appeal that a ruling in conformity therewith was erroneous. And that comes under play silly games, win silly prizes, doctrine of the law, which has existed for far longer than our country has. And then we note in our review of the cases Jones cites to support the proposition that a judge's authority to remove court-appointed criminal defense counsel is limited. We found none where the removed counsel had previously indicated a desire to withdraw if the proceedings were not conducted in the way counsel favored. Now, obviously, you're going to distinguish the Allen case here because these attorneys did not move to withdraw on their own. In fact, they stated at the time, we don't want to. We feel like we're being forced to. That's obviously very different here. Note at the bottom here, all justices concur the petition for writ of prohibition in mandamus is denied. Now, if I'm Allen's side, what I like about this case is that the Supreme Court considered this case, actually considered it, and says, are we within the limits here of what this judge can do? They did not say that this is not an appropriate forum or way to address this issue by mandamus. And that is what the AG and the judge are going to say in their briefs. So I think that goes to Allen's side. All right, so anyway, we've got done with that. So let's move it on to the actual briefs. That's what you're here for. Let's do it. I think I have to hit this button. Then I have to hit this button. And then, okay, I got the Attorney General one here. Sweet. All right, let me catch my breath here because I just got done doing some other things that it's sometimes hard to switch gears. Anyway, hello to Arizona. Let's pop that up there. That's a cool state. Many cool. I always think about things in these states when I see them, or countries for that matter. And of course, Indiana, which is the topic, the state topic that we're dealing with. And beautiful Holland, who cannot love all the real things about Holland that we see and just how great, at least over here in America, we're taught to imagine how beautiful it is. I think it probably matches it in real life. It seems like it. I've only been through there a little bit and probably not sober. All right, let's hit this brief from the Attorney General's office. Now, if you remember early in this, the Attorney General said, well, we're not going to represent the judge. And you could want to read into that they disagree with the judge, but you'll see here they don't on the material parts of the case. They filed this brief in the second action that has to do with the disqualification of counsel, the request to remove the judge and set a speedy trial date. They didn't file a brief in the stuff about the docket and all the documents being public. So that is kind of interesting. But they did appear here, and then so did the judge. So we will hit this and see what we got from the Attorney General's office. And the actual Attorney General, that's not unusual, even if they did anything on it or not. Chief Counsel of Appeals. All right. So cool. So let's take a look at the table of contents, and that'll give us a roadmap of where we're going to go. They don't quite do this in briefs, but the old public speaking theory of tell them what you're going to tell them, and tell them what you told them. So we'll start with the table of contents. This whole thing about reinstating these attorneys is inappropriate for writ. So I kind of threw the gauntlet down on that right away, because one of the cases they cite is this other case, and they actually did consider it for writ. They just didn't find that the writ was justified because the attorneys had been so boneheaded. So we'll see if they have better cases than that one. I mean, if I know they're coming at me on a technical basis, like you absolutely will on a writ of mandamus, having the court considering a writ is a good defense to the idea that it cannot or should not consider a writ, right? Even if the other side lost, because you'll be able to say, we didn't do any of the things these boneheads did. And when you considered their writ and you didn't even throw it out, you just decided they didn't substantiate it, and our writ is substantiated. So that's kind of what you want to do if you're Allen's side of the thing. And hello to Central Indiana. That's dunking on all the parts of Indiana that are not central, all the outlying parts of Indiana, sparsely populated. So I'm imagining that. I got some energy here because I've been sitting around. All right, so they're going to say that you can't do that, and that appeal is both the adequate and preferred way to review whether a trial court abused its discretion. And the rules are with them on that, because right in the original action rules, it says that these are disfavored, original actions, and appeals are favored. You cannot use these as a substitute for appeal. Is that what's going on here? We will be taking a look. This is hello to Liverpool, as we've said. Awesome. Good music background. And sadly, this isn't ending. It is just beginning. All right. Allen, appeal is both adequate and preferred to review this. Probably not if you're the defendant, right? If you're the person sitting in prison, you'd rather have it decided sooner rather than later. And again, I think also, if you think he did it, do you want to get all the way to conviction and then have the court look at this and go, oh, this judge messed up, let's do this whole trial over again? It doesn't sound appetizing either. So again, I'm kind of tilting here where I think this lands. And he doesn't identify an absolute duty to reject counsel's withdrawal or to permit them to reinitiate representation. We'll see about that. The right to choose counsel or continue representation is not absolute. That's certainly true. As the case law shows, the right to counsel must be balanced with the need for a fair trial, and that is true too. The lack of a record prevents counsel's disqualification. That one to me is an interesting argument to put up here, given the way this went down, because I wonder who had control over how the record was developed. Yeah, I think we all know what we're talking about tonight, which is these briefs are in. And, I've kind of developed the idea that I think Allen's side has the better of this, but we're going to look at these briefs and see if we're persuaded in the other direction, or maybe some of the viewers already think that this is should be denied. But let's take a look. I'll try to be fair and do the best I can for these positions, even though I'm not kind of on that. And hello to Canada. Was at Goose Bay one time, and in many other places in Canada when I got older, and some beautiful spots there too. Probably some nasty ones, but I didn't go to those. And the request of the court ordered the trial to commence within 70 days is improper, as he's not requested as relief in the trial court. I do agree with the state and also the judge on this, that if that you do that at the trial court level, you got to make the motion first. And in the instance that a new judge is appointed, that judge ought to set the date. And the request that the judge replace Judge Gull is improper, has not been properly presented to the trial court. But I think, though, for the original action rules, they say that change of venue from a judge is an exception to that. So we'll see. It would not surprise me if Allen's team says, hey, we'd like a chance to respond to this. What lawyer doesn't want to have the last word? And that'll be up to the Supreme Court whether they get that or not. All right, let's get into this Attorney General brief. So here comes the Attorney General appearing, blah, blah, blah. They do a lot of background that I'm not going to get into. You can imagine they spin it in their direction, but we all know what happened, right? They met in chambers, and the state had people ready to go. The defense did know that something was coming to a head. They just didn't know what was going to be said and the nature of it. And they find out from the judge that, hey, I think you did these things wrong, and I'm going to disqualify you if we go into open court, unless, wink, you want to withdraw out of the case. And then some serious argument ensued. And Baldwin made this oral motion to withdraw, and Rozzi said, I'll be filing one. I don't know that Rozzi's, how can that count as withdrawing if you haven't done it yet? And then also the Baldwin. But anyway, I'm not sure that they, kind of maybe surprisingly, that the parties here against Allen really rely on the withdrawals. That's an interesting thing, so we'll see. And there's a more serious discussion later about what the allegations of misconduct are by the defense counsel. We will certainly look at that because that matters. We just looked at a Supreme Court case out of Indiana that said if you play silly enough games, you'll get the silliest prize. So there are limits to what you can do as a lawyer. The court has to put up with it. That these lawyers do that, that's on the merits, at least, that'd be probably the best argument the judge has. So we certainly will touch on it. She did not want this in open court, but she would do it if she had to. So these attorneys were cajoling the judge to not make the record. I said I wouldn't get into this part. Let's get on to the argument. All right, an original action is a limited remedy governed by strict procedural rules. You've heard me boringly say that several times if you've been listening to these streams, but it's true. You are in technical land at this point. You're not in front of a jury where you make your best argument on the facts and you try and be as persuasive as you can with crafting a narrative that people understand and buy into. At the Supreme Court, you kind of want to do that, but you have got to make sure you color strictly within the lines. Your picture can be pretty, but if you're outside the lines, there's a good chance they'll kick it out because they have all these strict rules. So you kind of got to be careful here. But that doesn't mean that the mandamus writ is there for nothing. Okay, there are times when it's applicable, and let's see if this is it. Their view would disfavor it, and they can't be used as substitutes for appeals. This crowd that's listening, you already knew all that. You don't have to see the cites for that. Before a writ will be entertained, the relator must raise their question by written motion to the trial court. And that's generally true, although there were a couple of exceptions to that, but that's generally true. In other words, how can you come up on an emergency motion if you haven't given the judge an opportunity to decide on what you're talking about? That certainly makes sense, right? And if the remedy by way of appeal is full and adequate, the party may not invoke the jurisdiction of the court. So in other words, if the normal process works right, then don't try and convert things into a writ of mandamus just so you can get a quick decision in your favor. We won't really be listening to that. Now, note, the Supreme Court has not thrown either one of these writs out yet. I think we're going to get a decision on the merits. That's what I think. A writ of mandamus will not issue unless the relator has a clear and unquestioned right to relief. And respondents have failed to perform a clear, absolute, and imperative duty imposed by law. In other words, the writ of mandamus is not a place to ask the Supreme Court to sit around and go, I wonder if I would have done that differently. If I'd been there that day and I'd listened to that, maybe I would have come to a different... That's not what a writ of mandamus is. You have to be outside the lines, way out of your lane if you're the judge in one direction or the other. So everybody can agree on that law. And normally you do kind of start your briefs off with general principles of law that are hard to argue with, and then you start to dial it in. The request that the court reinstate Baldwin and Rozzi as Allen's court-appointed attorneys is inappropriate for a writ. A writ of mandamus is not presently warranted. When would it be warranted? The conditions precedent for a writ are not satisfied as the claim was not clearly presented to the trial court and a remedy by appeal is adequate. Now here I'm just going to go ahead and disagree with the Attorney General here because these guys noticed up appearances as retained counsel pro bono. And the judge is like, look, I'm not listening to any of this. You're disqualified, bro. And remember, she said, I don't even want the clerk entering this on the record. I don't want any of this stuff here. I don't want to ever see it again. Get it out of my sight. What more could you do if you're them to argue about your disqualification than what they did do? Even if you think they should be disqualified, you got to admit they tried to bring it up in front of the judge and she ruled on it. She said, no, you're disqualified. I find you grossly negligent. She said that out in open court after she threatened to do it in chambers. So has it not clearly presented to the trial court? Was anybody, to be fair here, was Judge Gull, was she stuttering? Was she mumbling? You couldn't understand what she said? Couldn't understand what Baldwin and Rozzi said? I think everybody knows where things stand at this point, which is she's decided they're off the case. They're off the case. So that being a reason to throw out the writ, I think to me, that should not fly. Now, even if the court were the court to review the merits of the Allen's request, the record is not sufficiently developed for the court to resolve the question. That is a way to punt. If the Supreme Court wants to punt, if they can say, well, we can't tell if the judge colored inside the lines or not here because there's not enough on the record, and it could be that she was within what discretion allows it could be not, and send it back down and tell the judge, you have X days to enter an order that justifies all this, and then we will review it. They could do that. That's a punt down the middle. It's not denying it or affirming it. But I still don't like this one either because I think the record is sufficiently developed for the court to resolve the question. And a matter of fact, in case you're wondering whether there's collusion between the judge and the AG's office on this, we're looking at the table of contents on her brief. I think she argues the merits of this. I think she says the record proves that I did the right decision. So that's a little bit of a conflict there. And if that's Judge Gull's position, and we'll look at it in a minute, then I would agree with that. I think there's enough information on the file, especially since the transcript is up from the hearing and we know the rest of it, that the Supreme Court can say, look, she was within her discretion or not. I don't think there's a mystery left. And so I see some people say, yeah, okay. All right, they're cool. Well, I'm trying to keep a weather eye on the comments. Appeal is both adequate and preferred to review whether a trial court abused its discretion in removing counsel. And that's true. If it's a discretionary ruling, it's not right for a writ of mandamus, and it generally is within the discretion of the trial court. But just like lawyers can't do just anything they want and say, well, my client has a Sixth Amendment right, so I can stand here naked in court, I can mock you and insult you, I can do whatever I want. The right doesn't go that far, bro. You can be kicked out. The judge also can't just do just whatever they want. And it is possible to be so outside the bounds of discretion that you end up in this writ territory. Oops, I got a wire on that. Allen did not seek an interlocutory appeal of either the trial court's order granting withdrawal of counsel or its subsequent order declining to allow counsel to appear pro bono. So they're saying you could have filed a form of appeal, one before the case, which is rarely granted. And that's what you should have done. And nor did Allen ask his newly appointed counsel to appeal. Oh, yeah, they were going to do that, right? And again, this is when you're an appeals lawyer, you like technical arguments. And this is a technical argument because, seriously, she told these guys, you're booted off the case. Here's the two new guys I'm appointing. They're supposed to be getting up for the case, get ready for the case, but now they're supposed to sit around and think about whether they want to appeal on Rozzy and Baldwin's behalf to get them back on the case. I don't buy that. And you know what? Why is an interlocutory appeal the right way to do it, but not a writ of mandamus? Because both of those would occur before the end of the case, not like a normal appeal. So this is not my persuaded face. Okay. Why didn't original action counsel file a limited appearance to seek certification of the court's order, as counsel did to file motions of preparation of this action? Why do fools fall in love? You know, maybe they could have done it that way. Does that make the writ, though, inappropriate in this case? Because they say here, which is a, kind of Hornbook law, the writ of mandamus cannot be used as a substitute for appeal. Yeah, we got that. This decision could have been appealed. So they're saying, hey, if you had an appeal and you could have used it, you should have. So this should be thrown out. And that is the general requirement. Disqualification of counsel can be required, or it can be at the discretion of the trial court. And those two things are true. The extraordinary remedy of a writ is not available where the matter is within the discretion of the trial court. And that is settled law. But again, the allegation by Allen's side is this isn't discretion. This is outside the bounds of what can be allowed. Okay. And they're going to have to convince the Supreme Court of that. This can't be something where maybe the judge had a good basis for this, because otherwise this isn't appropriate. So again, we're going to look at that because Judge Gull, I think, it comes straight at this, and that's good. So we'll get the issues on the record. Blah, blah, blah. You can't use the writ to adjudicate and establish a right to define and impose a duty. Though this court has reviewed disqualification of counsel through original actions, the court has not issued a writ to reverse a trial court's discretionary removal of counsel, but has issued writs where counsel's continued representation exceeded statutory authority. So they kind of concede the point here, though, right? That original actions about disqualification of counsel have been considered by the Supreme Court. In fact, they were considered in the case that I talked about earlier, which is cited by the Attorney General's office here. What they're saying, though, is those cases only involve the counsel's exceeding statutory authority and not the discretionary decision of the judge. So they're saying that it's black or white, that the appeals court could look at that and see whether they're outside statutory bounds or not. And there's nothing discretionary about it. But if it's discretionary, you should just let the judge do it. That's kind of what they're saying there. And I see the comment here, appeal after trial. Now, what they are saying here is that they see a mechanism for an interlocutory appeal, which is an appeal that you can do during the conduct of a case. But if that's what you're suggesting, if you're the AG's office, then why not just go ahead and deal with it with this writ? So that's kind of up to the Supreme Court to decide, I think, here. But they do admit, the AG's office does admit that writs of mandamus have been considered by the court before for matters of counsel disqualification. That's obviously good this part is good for Allen, because Allen's got two hurdles. He's got to convince the Supreme Court, you should hear this at least. This is the kind of thing that a writ of mandamus is for. And that's a big hurdle. And then the second one is Now you should approve this writ of mandamus. You should grant it. And that's the second hurdle. And I see somebody saying they talk around the Supreme Court of Indiana is that they'll accept Gull's response and deny the defense writ because he didn't file the interlocutory appeal. And that being true, I wonder why ever consider a writ of mandamus from the point of counsel then, disqualification of counsel, because that would just be the way to handle it every time. And I'm not saying you're wrong, because it is a defect if you can do this through appeal. But if that's the case, then why didn't they go ahead and throw it out? But we'll see. We will see. And here they quote some cases, right? Granting writ to disqualify special prosecutor, granting writ to remove private counsel retained for a state agency, denying writ to reinstate disqualified attorneys where they requested to withdraw if not granted a certain motion. That's the case that I talked about. So in that case, they considered the writ. They didn't throw it out on the basis of you could have done an appeal, which they certainly could have. Instead, they considered it. They just didn't find it substantiated. So I'm not going to say that they won't throw this out on a technical basis, but it strikes me that that they're going to move forward with this. But again, we got to finish looking at these briefs. Appellate courts have reviewed discretionary removal of counsel through interlocutory appeal, but they also just showed that they also have done it through writ of mandamus. So we'll see. That's the argument, though, and it's very fair to make a technical argument because if you don't have one of the foundations for the writ, then you never get to the merits. So naturally, it's going to be attacked there. Allen does not identify an absolute duty to reject counsel's withdrawal or permit them to reinitiate representation. And, it's probably not an absolute duty to reject their withdrawal if they're trying to withdraw. They're talking about that it's ineffective or to permit them to reinitiate representation. Yeah, I don't know about that second part because it's to some degree because of the distinction between privately retained counsel and court-appointed counsel. That the choice of counsel really comes in when you have privately retained counsel, which Rozzi and Baldwin agreed to do. So I think it's interesting to tell an attorney, we're not going to allow you to appear in this case as privately retained based on my decision that you're incompetent. And not have that reviewed by the higher court. But the question is whether it's interlocutory or whether it's through this other method. And hey, guess what? If this were to get denied and the court were to say you should file an interlocutory appeal, guess what's going to happen? So they can do this work more than once or they can go ahead and deal with it. All right. The law does not place an absolute duty upon courts not to interfere with the attorney-client relationship. It bars arbitrary and unjustified interference. And that's what Allen's team is saying here. And this is good. This is certainly correct law. Because sometimes people say, what about your Sixth Amendment right? You have an absolute right to the counsel and counsel of your choice. There aren't any of these things. None of them. There's no part of the Constitution that isn't interpreted by the courts and limited in some way, some reasonable kinds of limitations placed on things. I mean, for example, the First Amendment doesn't mean that I can come to your house and scream in your living room at 2 a.m. And then if you call the police, I can argue about state action infringing upon my freedom of speech because there's time, place, and manner restrictions. There's, the different things that you can look at for all the rights. And so sometimes the court is authorized, as we discussed in earlier cases, if the attorney goes absolutely bonkers, the court can throw them out and you're not going to be able to hide behind your client's Sixth Amendment rights. So you have to kind of understand that interplay there of the right that the defendant has and then also what the potential limits of that are. And it's part of what a good court order would do. Would say, here are the rights that this person has. Here's what justifies interfering with that right, the balance of these things and why it's extraordinary. And I should take these people off the case. And we didn't get that in this case, which is one reason why the court could punt it back for a more explicit order, but also another reason why they might just terminate the order, unless of course they punt it out on some kind of procedural grounds like you could have appealed. Allen contends that the respondent acted to terminate the attorney-client relationship when she had an absolute duty to refrain from doing so, but they don't identify the origin of this absolute duty. Well, the absolute duty, that's part of the technical language that you got to have for the writ. And I guess if you're Allen's side, you're going to say, well, you have a duty, one that you can't get away from, Judge, that your discretion can't be arbitrary and capricious, essentially, to quote some other standard of law that came into mind. So I think that's the idea behind that. And Allen's brief does not contain a verbatim statement of the relevant parts of all cases, statute authorities relied upon. So again, they're hammering on this thing on the technical side, which is fine. A trial court's authority to remove counsel is more nuanced and less absolute than Allen suggests. And I agree with that. I think their brief was too narrow in their concept of the law. For example, we saw earlier where the Indiana Supreme Court allowed the removal of counsel when the judge removed them for making fun of the court and filing sarcastic things in the filings and stuff like that. And sarcastically / seriously moving to withdrawal, they said, you're gone and you ain't coming back. So the Indiana Supreme Court has recognized some limits on that in other cases. She has the absolute duty to follow due process. Last I checked. Well, yeah, and that's my point about the order. Like the order ought to have in it what the standards are, okay, and what the findings of fact are, applying those within the balance of the law, and then the conclusion for the decision. So I don't see that, and so that's in this so far, or didn't see it in what she did. That's why I'm kind of leaning Allen's way for the most part. That plus, I think the merits of the thing. The Sixth Amendment guarantees every defendant the assistance of counsel. The Attorney General says we all agree with that. And if you don't need a counsel appointed, you have the right to choose counsel. And that's generally true too. Indigent defendants don't have the right to pick which counsel they have. That's basically what the law is. There's not a right to continuity representation and not a right to the quote unquote meaningful relationship with counsel. That doesn't mean those aren't things that the court should consider. We're talking about a right, and the meaningful relationship one came up in the context of a case that would have been substantially delayed if you were waiting for this lawyer to heal up and come back into the case. So it's not that it doesn't exist as a concern. It's just we're talking about whether it's a right or not. The Sixth Amendment imposes a baseline requirement of competence on whatever lawyer is chosen or appointed, and that's certainly true too. Somebody says he doesn't need counsel, pointing out they're offering to be private counsel pro bono. Right, and I think they've done more than offer that. They entered an appearance as privately retained counsel. So I think that was, to me, that's an important move that they did. Whether it's going to matter and how this gets decided, we'll see. But they absolutely put their money where their mouth was there. The right to choose counsel is not absolute. That's true. That's solid law. The essential aim of the amendment is to guarantee effective advocate rather than ensure that the defendant will inexorably be represented by the lawyer whom he prefers. True. And of course, not the situation we're dealing with here, but good law. Good talk about the law there. Retained counsel, courts must recognize a presumption in favor of the defendant's counsel of choice. And so remember, they appeared as retained counsel, okay, privately retained counsel. That's what they did when they appeared pro bono. And Indiana has not addressed whether retained versus appointed counsel alters a court's authority to substitute counsel. It's mixed in other jurisdictions. In some, it certainly does do that. And certainly for choice of counsel, it can matter a lot. So they talk about some things there. Any right of continuity counsel must flow from the right to choose counsel, and indigent defendants lack that. Okay. But right is different than an interest to be balanced. It doesn't mean it's irrelevant. Yeah, see, the court recognized that they have an interest in continued representation if they can demonstrate a prejudice would result from substitution with a different court-appointed attorney. I would consider it prejudicial to my life if I had to spend another year in prison because a new lawyer had to get up to speed. So if you're going to do that to me, you ought to have some good reasons to do it. And again, the judge may have those good reasons, but the point is there is obviously an interest on Allen's side to staying with the lawyers that he apparently likes, who he thinks are working hard on this case, and who were essentially ready to get on to trial. Trial courts must give great weight to a defendant's preference. Did you see that in the judge's order? Did she give great weight to Allen's preference? I don't know about that. And so the AG says here that the law says trial courts must weigh a defendant's preference for representation against the circumstances favoring disqualification. If your order only talks about what the lawyers did and doesn't weigh the defendant's preference and these other things, are you really exercising your discretion within lawful bounds? And that's why I say a good order is your best foundation to not to be appealed. And in a lot of cases, at least, I don't know about criminal ones, but the ones that I would do, civil, if you win the motion or something, a lot of times you get to propose the winning order to the judge to adopt, and you try and make it as appeal proof as you can. I didn't hear really. I mean, I think the trial court said, the judge said at the hearing at the end of the month, I know that you want to keep these lawyers, but I'm just not going to let you do it. And seeing those things from the bench, you know, is that really, that's not really how you do the order in terms of balancing interest and stuff like that. That's my opinion. They may find it differently, but that's my opinion. The right to counsel must be balanced with the need for a fair trial. Okay. Contrary to Allen's claims, more than two circumstances may require a court to interfere with the defendant's preference for counsel. And in their brief, they said you cannot insist upon counsel for somebody who is not admitted to practice, and if there's a serious conflict of interest. And they say Allen's counsel didn't recognize that there's more circumstances than that. And the AG is correct there. The AG is absolutely correct on the law there. There are other ways that a court can remove counsel and it'd be okay. And it usually has to do with trying to substitute counsel or bring counsel in on the defendant's part as a way to delay the trial further. That's usually the case, or that's the cases that I saw. Counsel's conduct or personal circumstances may justify removal. Gross incompetence and all of that stuff may justify the court's removal of an attorney, even over defendant's objection. Right. If the guy's showing up drunk all the time and won't wear any clothes and screaming at random times, threatening people, you're not going to let that lawyer stay there and then go, well, I have to let them do whatever they want because it's the Sixth Amendment right. So, of course, there's more than those two circumstances where that can occur. Trial court may disqualify an attorney for a violation of the rules of professional conduct. And a defendant may not insist on the counsel of an attorney its previous ongoing relationship. So these are more examples of ways that a judge can disqualify counsel. And there are those ways. Okay. It's not that, again, it's not an unfettered right. The need for efficient administration of justice may require removal. And that's an interesting one to bring up here. There was the one talking about counsel indefinitely unavailable due to illness, right? So you don't have a right to have your case on ice forever just to see if your lawyer gets better or not. That's unfortunate, but they need to move on with things. These cases, as this one points to, are usually the situation where the defense is the one trying to delay the case. And the judge is like, well, we got to get on with it. So let's go with the lawyer who can show up with court and not a lawyer that isn't here. And this is the reverse, because Allen's attorneys that he had were ready to go to trial, and the new attorneys justifiably are not ready to go to trial because they haven't been working on this case. And they probably have other cases they're working on. So, and somebody asked a good question. Why didn't the AG represent the judge if the AG agrees? And we got to look at the judge's brief because the judge may have different positions than the AG. So, and there may be some other interplay of how and when they represent judges and stuff up there. It can depend. I can tell you that for sure, at least down here. And while the denial of a continuance may infringe on the defendant's right to counsel, a denial of a continuance. And again, Allen's the one who was trying to get to court fast. So this is the reverse. Court must also balance the needs of the public and victims. They have an interest in even-handed administration of justice. And I did see some people take issue with the DA in this case, saying that we're entitled to a fair trial too. And I mean, the rights belong to the defendant in this case, okay? But you can see here they're saying that there should be an even-handed administration of justice. For example, just because you have rights as a defendant doesn't mean you can string your case on for 6 years, constantly swapping out counsel and stuff like that. There are other competing interests here, like let's get this case over with. The trial court has the discretion to balance these interests with the defendant's desire to be represented by his preferred counsel. And that's true, but so far as we know, those interests from Allen's standpoint is he's the one who wanted to go ahead and get the trial over, which is usually what you want. Varied interests may necessitate overriding a defendant's preference. Disqualification is an extreme remedy that should only be used when a court deems it reasonably necessary to ensure integrity of the fact-finding process and other things like that. So even the AG is saying here, it's an extreme remedy, take somebody out of the case. So if it's an extreme remedy, it should have some serious justification to it. And that's why I think it's reasonable to be considering this at this point. The lack of the record prevents review of counsel's disqualification. Now, here's where, if I could still read while squinting, that's what I would be doing, because they blame us all on the defense. Defense counsel's withdrawal truncated the proceedings, and the present record prohibits complete review of whether the trial court's concerns justified substitution of counsel. But I think, reading and glancing at the judge's table of contents, that the judge is going to talk about the basis for this and say it is on the record. And in that case, I would agree with the judge. I don't think there's a dodge here. I think the Supreme Court needs to look, if they get this far, then they need to look at it and say she was within the bounds of discretion or not. In chambers prior to the October 19th hearing, the court listed the reasons it felt counsel should be disqualified that it intended to address in the hearing. Right, and we have a transcript of that, so we know what those reasons were. Prosecutor was prepared to present evidence from the leak. This hearing did not occur because defense counsel withdrew rather than challenge the factual allegations at that time. Well, one of them made an oral motion to withdraw, and the other one said, I will file a motion to withdraw, which to me is like a New Year's resolution. You know, I'm gonna exercise 6 days a week is not the same as exercising 6 days a week. Somebody says it sounds like the AG is accidentally arguing against himself in some of this, and that's a fair comment. But again, remember, it's not strictly representing the judge here, although it is opposing Allen's position. So the position of the AG can be more nuanced than the judge may choose to be if we actually get to look at her brief at the rate that I'm going at this. Anyway, when Baldwin and Rozzi attempted to appear for Allen, had their own counsel. No additional evidence was offered or arguments made to rebut the court's allegations. Well, there were no arguments to rebut the allegations, but then there was also no facts on the record then to substantiate these allegations either, right? Because the judge did say they're disqualified. So where are the facts to support it on the record? The AG says it's an extreme remedy, so there should be some extreme facts on the record. And it's not just up to the defense to rebut them and to make sure it gets on the record. The judge is the one doing the disqualification, not the defense. And so I don't like this type of logic here in terms of being persuasive. Respondent raised concerns that could warrant disqualification depending on the circumstances. And they talked about the counsel's compliance with professional ethics and stuff, and a little bit about what that is. So the judge raised concerns that could warrant disqualification. Well, if you're given an order for disqualification, then could do it. How about do it? Express about candor. I'm more interested in what the judge has to say this than this record does not contain the transcripts necessary to evaluate these concerns. I think that transcript is up there, bro. Concerns about competent representation. Everybody's concerned about Richard Allen, except for they're not concerned about what he wants in this case. So I'm not sure I'm buying the sincerity of that position. Attorneys making false, misleading statements to the tribunal, and that conduct can be prejudicial. Yeah, and it comes back, and the judge did say something about that. We certainly won't dodge it ourselves. There could be a conflict of interest. They let the leaks out and all that stuff, so we'll get into that, and we can see what the judge has to say about it. It's kind of funny, though, that they have all, it's a big mystery. We don't really know why the judge did what she did. And then they're spending, 2 pages with exact knowledge of what the judge says justifies her position. So, and here's the thing. It's not really whether Rozzi and Baldwin can rebut this, because if it's findings of fact, then it probably is within the judge's discretion. I think what the Supreme Court ought to look at it and say, well, without putting pejoratives on it or slanting it, if these facts occurred, could she have disqualified them? Would that justify the disqualification? And if so, she's probably within her discretion. But if those 5 things under the law don't justify discretion, you don't need to have 16 witnesses testifying about whether it happened or not, because it would be insufficient as a matter of law. All right, let's keep this rolling. Come on, man. The record is also inadequate for full consideration of Allen's preferences. It did have his desire to retain them, but it doesn't show that he knew or understood about what the leak was and court's other concerns about counsel's competence. And how many trials have you seen where the judge talks to the defendant and says, do you understand this? Do you know what's happening? I mean, that happened with Darrell Brooks before his counsel was fired. That happened with Koberger. That's happening there. So if you're going to be disqualifying these attorneys, and whether Allen understands what's going on is a concern or not, who's in control of the courtroom? That's my question there. Who's controlling the situation? All right. So, and we will get to these allegations later. But my point is, if you have to think about whether they're true or not, then probably writ of mandamus is not where you go. But if you say, look, even if these things are true, they still shouldn't be disqualified, then it's more likely that you could get the writ considered. Limited review in this action is inappropriate. Courts have discretion to remove counsel for gross incompetence or inappropriate conduct cannot be adequately addressed through contempt. Is the stuff these guys did something that can't be adequately dealt with by contempt? I don't know. This requires more than general concerns as counsel's not handling the case as well as they should. Okay. All right, we already covered all this. Allen seeks a combination of relief: reinstatement of counsel, removal of the judge, trial within 70 days. It would not permit the judge or any other judge to undertake further proceedings. So they're saying if you gave Allen everything he wanted, you couldn't go back down to the court and think about this more and establish a better record. I guess it's my contention you don't need a better record, because if it's whether it happened or not, more or less, the judge would win that one, because the judge can do the fact finding on that. However, if these things did happen, okay, could the judge make this decision? And the answer is no, then they're in the right place for that. So I know the allegations were in chambers, but let me make the point that now that transcript is at the appellate level or at the Supreme Court level. And I believe, which we'll see in a minute, that it's also in the judge's brief. So it'd be hard for the judge and the AG, I think, to say, we don't know what the allegations were and what they are, but also here's the list of all the allegations. And the judge, I know, has that coming up in the brief. So let's get over to that one. What does the judge got to say? Because this is going back, wavering back and forth with the AG. So the requested the court order trial to commence within 70 days is improper. I agree with that one. They want the trial to commence within 70 days of the issuance of the writ. I don't think so. He has not moved for an early trial under the Indiana Criminal Rule 4. He signed a motion in August, but they hadn't filed it yet. That's the definition of you didn't ask the trial court to go ahead and rule on your motion or not. And also, if you do get the new judge, the judge should be presented with that and then set the case up for trial. The Supreme Court shouldn't be handling the docket. So I don't think he gets that one. That's my opinion. It's a big loser, but not these other ones. So now the final one here we'll look at before we switch over: the request that this court replace Judge Gull is improper, as that request has not been properly presented to the trial court. So this is the technical argument that whether she did something wrong or not, you're supposed to direct it to her first. But I thought my reading, or I know my reading of the rules are, that's an exception for condition precedent for an original action here, but whatever. Let's see what they say about it. Also, by the way, they did file it, and the court said, well, I'm not going to look at it because you're not the lawyers anymore. And so that is kind of put in front of the trial court, and you can take that as a denial of your motion when the judge goes, I'm not even going to look at it. Well, I mean, what else can you do at that point? They're saying the request is improper as Allen's not asked for this relief from a trial court, but he did file that. And they admit it's true that after he withdrew, did he withdraw? Rozzi filed a motion to disqualify, but he was no longer Allen's attorney. I don't agree with that. Factually, I don't agree with it. Allen cites no authority. The trial court must entertain a motion by an attorney who's not the party's current attorney. And I don't know remember exactly the dates and things, but he was also saying, look, I'm in this case pro bono, baby. So, but they're trying to say technically he didn't meet it. But then they also say that he failed to show that a remedy by appeal is not adequate. The appellate, and they're saying it could be interlocutory again, right? So you could file an appeal at the same time you could have filed this. That's what you should have done. Okay. What's the difference? He can file his motion for change of judge, and if denied, he can appeal that decision. Well, he can't get it denied because the judge said, I won't even read it. And they say, finally, they get to the merits. The judge is biased. This is not sufficient to just say that the judge is biased. Look how much they give time to that. One paragraph. The mere assertion that certain adverse rulings constitute bias and prejudice is not established the records showing. That's true. That's good law right there, right? And so they say the record doesn't support it, but they either ran out of space or they just decided not to argue that very hard because they didn't do much there, did they? Now let's flip the script over to the judge and see what that is. Window. Here we go. Okay. There. Yep. Sorry about that. Technical difficulties. Somebody said, I think when the judge shows up in chambers with a written order without having had a hearing or accepting a written motion, she's biased. Maybe. It's not a great indication of unbiased, is it? Especially when that order is, you're being thrown out of the case. I believe that it all depends, because if you could have had the hearing, you could have put everything on the record, you could have written an order that shows the elements of the law, the balance and all that stuff, and justified it. And that would have made this simpler from a legal standpoint. All right, so let's see what this is Judge Gull's argument right here, okay? Let's rock right into it so we can, it's supper time somewhere and soon here. This court has never issued a writ to reinstate a criminal defendant's counsel whom the trial court removed for engaging in multiple acts of gross negligence, causing the trial court to conclude that the accused was not receiving competent representation. So right out of the bat, she may be sick at home and all that, but she's not sick of this case. She's not going anywhere. She's firing hard at defense counsel here for what her position is. And she didn't violate an absolute duty. So now we're back on the technical thing here. Remedies on appeal are wholly adequate. We'll see about that. These cases are routinely resolved regarding a defendant's Sixth Amendment right through the ordinary appellate process. So whether they withdrew or were removed, the court should deny this petition. Again, not real strong positions by the AG, or I think coming from the judge, about the effectiveness of this withdrawal. I don't think that a lot of things were skirted in that on every side, I think. Anyway, relator's Sixth Amendment right to effective assistance of counsel, Allen, outweighs his limited right to select his counsel. So she's saying, look, this counsel was so bad, that was more important to me than the fact that you wanted them to be your lawyers. Okay. Let's see. Respondent has discretion to remove. Okay, so she's saying they were providing ineffective assistance of counsel. So they're hitting it. They're hitting it right here. They're saying I had to get them out of here because they were incompetent and ineffective assistance of counsel. And remember, it's a big mystery about why she thinks this. No way any court could tell from the, who could even know, and it's the defense's fault. But yet here she says that they failed on multiple occasions to take reasonable steps to safeguard confidential case materials, made extrajudicial statements that had a material likelihood of prejudicing the case, provided false information to the court. So again, if those things, if true, justify what she's doing, that's one thing. But I think it dunks on the argument that who could even know what happened at the lower court. The judge is saying it. Okay, so that's why I say that I think this is more ripe than that point of the AG's brief was trying to make on here. And they had notice and opportunity to be heard through written submissions as well as argument in chambers. There certainly was some debate about that. I think the issue was they felt like they didn't get a notice of what the actual hearing was about, and the prosecutor had brought a lot of stuff, and there was not the normal procedure of if the prosecutor was having this motion, which the prosecutor didn't make, I think, to disqualify these people, had supporting evidence and stuff, that gets filed, then a response gets filed, kind of like this is being handled. You don't just show up for an oral argument at the Supreme Court with no prior documents. Positions get put on the record. And she's saying that her adverse rulings don't demonstrate a personal bias or prejudice. All right, so let's get into this. The Supreme Court can confine a lower court within its lawful jurisdiction. Everybody agrees that. Extraordinary remedy. How many times have we got to hear that? Clear and unquestioned right to relief. Only where the trial court has absolute duty. All right. So fails the mandatory procedural requirement. So again, you can expect the technical argument and you're getting it. This court never issued a writ to reinstate counsel. And we already heard that. The court's reasonable findings that counsel had engaged in multiple acts of gross negligence, compromising the accused's constitutional right to competent assistance of counsel. And look, if that's the situation, then the judge would be doing the right thing to take counsel off the case, okay? Contrary to relator's assertion, neither this court nor the U.S. Supreme Court has held that a trial court may remove in only two circumstances. And I agree with that, Allen's counsel, to the degree that you could read it that way. That's more limited than what the law allows for taking counsel off a case. It's clear that there are other circumstances that allow that. And then they go back to our old favorite, Jones versus Knox Superior Court, the case we talked about at the beginning of the stream, where a writ of mandamus was considered, but under the doctrine of play silly games, get silly prizes, the counsel who were sua sponte, taken off the case, remained off the case. And the judge cites it here, that a writ of mandamus was sought to reinstate the attorneys. The court denied the petition. Note that the court didn't throw out the petition for not meeting a procedural requirement. The court denied it. And then in dictum, I mean, it's not the holding of the case. Generally, the view of trial court is limited in its authority to remove a criminal defendant's court-appointed counsel, but here we won't explicate the parameters. But this case, they might. All right. Relator relies for the most part on cases outside Indiana. Yeah, and to some degree, there's a dearth of exact cases on point for this type of thing because it is very rare. And she's right. Cases from outside the state, they're not binding on the trial court. And they're just informative to the degree that you want them to be when it's some other state's ruling in your state. When interpreting the Sixth Amendment, the trial court must follow the law of Indiana's appellate courts and the United States Supreme Court. Yep. Okay. And they're saying there's no clear right to an extraordinary writ. Okay. We'll see how the Supreme Court answers that. That's a technical argument you got to make. It's fair to make it. I don't buy it. Okay. Then you got to show that the remedy by appeal will be wholly inadequate. Far too frequently, writs of prohibition and mandate are sought to be used as a shortcut to an appeal on merits, which cannot be done. She's saying, hey, if you like these other cases, bring those up on interlocutory or direct appeal. You can't circumvent the normal appellate process. And these kind of things, she says, are routinely challenged on interlocutory direct appeal, including disputes about choice, removal of counsel. And at many of the cases Allen cites are cases on appeal. These are good arguments by the judge here. That defeats Allen's argument that his assertion that his remedy available by appeal would be wholly inadequate. Maybe the interlocutory part, right? At least I don't know how fast they do that. But I still go back to the fact that in that other case, that Jones case, they didn't throw out the petition on this basis. They considered it. So we'll see. I mean, it is possible that this would get kicked out that way, but I don't know then why it wouldn't have already been kicked out. Because if any throwing out of counsel can be done by interlocutory appeal, then why is the Supreme Court even listening to this so far? Let's see. This would be the first time in Indiana that the Sixth Amendment prohibits a trial court from removing counsel when the court has reasonably found them to be grossly negligent. So we'll see about that. I don't know, is the finding reasonable or not? There's certainly a format for that, and the judge believes it. We're going to find out pretty soon if she's right or not. But she says, look, I didn't even violate his Sixth Amendment rights by removing his counsel because his effective assistance to counsel outweighs his limited right to select counsel. And that's a reasonable position to say. If you've got an attorney not meeting the minimum standards of being an attorney, then deal with it. But let's see where she goes with this. Effective advocate. She properly exercised her discretion to protect the Sixth Amendment right to effective assistance counsel by removing Baldwin and Rozzi. Right. Again, we know about the limits of choosing one's counsel. We've already gone back over that. Broad discretion, considerable discretion, great latitude. Discretion is necessary. The tension, gross incompetence. Can it be cured? For contempt may justify removal. Blah, blah, blah. Now look at this. Moreover, the trial court need not delay taking remedial action until counsel's incompetent representation causes the entire trial proceedings to be constitutionally defective. We must remember that reversals are all but palliatives. The cure lies in those remedial measures that will prevent the prejudice at its inception. Is she saying what I think she's saying? Which is that if we have an issue with counsel, that rather than let the whole trial go on and be a big fat waste, that you ought to go ahead and deal with the issue right now. Because I agree with her, if they're incompetent, dealing with it on the front end of the trial is better than dealing with it on the back end of the trial. But I also think if she exceeded her discretion to the beyond the limits of the law, that would also, her argument supports Allen. If he's correct, that she exceeded her discretion, then an appeal is not the right remedy for this, at least not an appeal at the end of the trial. Maybe an interlocutory would be different. But you got to prevent the prejudice at its inception. So Allen might want to, I know they said he was eating papers he gets. He wouldn't want to eat this one. He might want to keep this page. Okay. Obligation to foresee problems over representation that might arise at trial and head them off beforehand. And I agree with that. Why have two trials when you can just have one? And they say, okay, here. She says, I acted well within her discretion to remove Baldwin and Rozzi over Allen's objections. The record supports the trial court could reasonably conclude that he committed multiple violations of the rules, compromised his defense, and the totality of the circumstances demonstrated gross negligence and incompetence. If the Supreme Court agrees with those conclusions, then Allen loses this, right? And he doesn't get Baldwin and Rozzi back. And here she goes. I knew it was coming. Remember, the AG said, who can even know really what happened down that level? We don't have the record and all that. It's in bold, yo. Baldwin and Rozzi failed to take reasonable steps to safeguard confidential case materials, including crime scene photos. And we all know by now what happened there. Mitchell Westerman went in there and took some pictures. He shouldn't have done it. He's been criminally charged for that. Let's see. Terrible circumstances resulted from that. Rozzi and Baldwin agreed to use Baldwin's conference room as a home base for confidential case materials. And so here's they're trying to implicate Rozzi into this because Rozzi wasn't there. It wasn't Rozzi's conference room table and all that. Rozzi understood that Westerman would regularly visit Baldwin's office and that information would be shared with him. Did he understand that? Yeah, I mean, maybe, but I don't know about that. Baldwin emailed confidential work product to an unauthorized person and failed to timely report the leak to the trial court or prosecutor. So he intended to send it to Rozzi, but he accidentally sent it to Brandon Woodhouse, a defendant in an unrelated criminal case. So that's certainly a boo-boo. Sometimes discovery mistakes happen. I mean, it's certainly disturbing, these pictures getting out there, but I'm afraid I put the blame for that on the guy who took the pictures, Westerman, more than I do Baldwin. It's not like Baldwin left his office unlocked and went out to dinner and people just came in there and took pictures, just random people. He's dealing with somebody I think had a JD and somebody who trusted and worked for him and stuff like that. It seems pretty unfair to me to throw Baldwin off for that, and also Rozzi, who wasn't there. That's my opinion. But again, so you take number one and you look at it and you say, if this is true, does this warrant throwing these guys off the case? You look at that for each of these, and then you say, cumulatively, should they be thrown off the case for these things? And that's what we'll look at. We did the email, so that's 2. Again, the judge is just walking these things down. And the AG will enjoy reading this because the AG couldn't ferret from the record what was actually the justification for the judge's order. But here she's putting it out in numerical order. They made extrajudicial statements that had a substantial likelihood of materially prejudicing the case. They included in their press release detailed extrajudicial statements about the case, along with information that would normally be revealed, and proclaimed his innocence. Is that awful? Is that really that awful? And again, we're not on the merits of this thing. I think the timeline looks really bad for Richard Allen, but I know that the defense counsel early in this said, listen, we're going to contest this bullet that was found. Our guy's innocent and all that. Is that a stunner? Is that a shocker to hear a defense lawyer say, my guy didn't do it, whether they did it or not? I mean, I didn't read their press release and go, well, they just need to throw this case out then. You know that there's some posturing going on by the state and the defense at that point. So anyway, they didn't limit their press release to information that the rule expressly permits, and nor did they limit it to what was necessary to mitigate adverse publicity. Maybe, I guess would be all you could say for that. Potentially violated. There's a lot of potentials in here, isn't it? They knew at the time that the state had filed a motion for a gag order and it was pending. So in other words, the gag order wasn't out yet. Okay. In fact, that press release prompted the trial court to issue the gag order. Now, they didn't do any more press releases after that. Although I think that Frank's memo was viewed by the prosecution and probably the judge as a form of a press release, and was a factor in this, whether it gets admitted or not. That's just my opinion. So it says you're not allowed to say you're innocent. Yeah, I'm afraid that I don't think that the defense lawyer saying my guy didn't do it is like a shocking revelation that you would never expect. And once that is said, let this guy free. And I don't, I'm not surprised that they would say, the magic bullet, we're going to dispute it and stuff. They said it once in a press release, and then it settles back down and becomes what it should be, which is litigated in the court. And of course, they filed a motion to suppress where they're going to challenge the type of science used, and that can go back and forth, and eventually it gets into court. I just didn't see them as doing something that bad there. They provided false information to the trial court. Now, that is kind of serious here, allegation. The state presented evidence that clearly demonstrated the falsity of relators' claims. And I think that probably matters in which ones exactly were false. The evidence presented at the hearing did not support many of the allegations advanced by defense counsel. Now, I personally thought some of what defense counsel said was over the top, hyperbole, and a lot of flowery language and drama and stuff. I'm not going to hold that against them. Now, if they said particular things that they knew were lies at the time they said it, I kind of feel like that probably should have been addressed at that time. If the court felt like at that time you lied, you intentionally lied on this motion, then a sanction would have been warranted at that time. So I don't know. The fact that you disagree with the defense counsel's ruling there isn't the same thing as them lying. The fact that maybe some of the facts come out that show that they're incorrect doesn't mean that they lied. That's a fairly high standard. And I feel like the fact it didn't get addressed at the time, because I don't think it really did in terms of a sanction or anything, maybe mitigates about really how important it is. I mean, they were trying to get the guy out of prison, right? So they get him to jail, and they got to go hard at that. Don't you want them to go hard? So I don't know if they lied or they didn't lie, but that's a little vague to me. So all these things happen. And of course, the last one was the leak of these photographs by Westerman. It was at the final event. The trial court became gravely concerned with his right to have competent, non-negligent representation. Did I miss one? Because I also, somewhere in this was that they filed that civil claim notice, which I don't think is a big issue. So she's saying, based on these things, you take them all into context, and you could reasonably conclude that his representation objectively fell short of the prevailing professional norms, and counsel's deficient performance prejudiced the defense. So I like this because she's saying this is objective. And so the Supreme Court should be able to look at this and say, well, maybe 9 judges out of 10 wouldn't agree with you, but 1 out of 10 could. You know, we wouldn't do it ourselves, but it could be felt this way. Then he loses his writ. But if objectively you look at all these things and say, if this is what you got, you can't throw these guys off the case, then Allen ought to win his writ. That's how I look at it. And that's a matter of judgment. And professional norms, deficient performance, prejudice the defense. And she's making the judgment here that what the counsel were doing was actually making Allen's case harder to deal with. Okay. I mean, one of the reasons why it was so hard to assess this case is so many things were kept secret. And part of that is because of case security and making sure that, you maybe have some information that whoever did it doesn't know, so that you have, so that maybe you can get the evidence later before they destroy it. Or if somebody wants to confess and it's false or real, there'd be something there that you could ferret from them to find out whether they were really there or not. Those are good reasons to hold things secret. Also respect for the victims. But I think everybody knows in this case, things were just filed under seal as a matter of routine, whether it should have been or not. And that has amped up the level of speculation on the case. You're allowed to have negligent counsel, someone said once. Well, if you've got incompetent counsel, then you're likely going to have your conviction reversed. So if the judge sees that as a matter of certainty, I think she's right. She should take action. But, a lot of times that might be the dude I don't mean to be gender specific. The defense counsel not performing to the minimum level the counsel should, falling asleep in the case, not bothering to question people, doesn't send out subpoenas and things like that. Just absolute nonsense like that. It's certainly ineffective assistance of counsel. And these things seem like there's 2 things here that were mistakes, and that's the email that went out and the leaking of the pictures that, that shouldn't have happened. And I don't know that that's really incompetent for Allen's case enough to throw them off of the case. So I just don't buy that. But I appreciate that she says this is objectively so. So the Supreme Court could say, well, if those things happened, the judge was within the bounds to do it. And if those things happened, the judge wasn't in bounds to do it. I think that sets that issue up nicely. And the question is, does Allen think he has bad attorneys? And from what we know, he did not think he had bad attorneys. But his decision is not final on that. He's not the lawyer, and he might not even know if they were screwing up the case totally, legally speaking. And I have seen that happen. Where people don't even know that they're being highly prejudiced because of an incompetent attorney. So if the court were to see that in dramatic fashion, I don't think we want to say a trial judge has to blindly allow somebody being led to the gallows by a lawyer who is failing to perform professionally in a way that the judge clearly sees and the client may not understand. And we don't want that just to justify being against the judge's decision in this case, right? Again, I think there is a discretion level there for the judge. The question is, do these acts here in this case compromise such that it would be within her discretion or outside of her discretion? And she set out what her justification is. So her conclusion about whether it compromises Allen's defense is something different than her statement of the facts that she says are on the record that she's relying on. Theirs aren't the same things. she gave him adequate notice and opportunity to be heard before removing him as counsel. And there's no statute requiring notice, a hearing, or opportunity to be heard, but she says, I did do that. And I know, of course, Allen's side takes offense to that and says, we didn't get adequate notice. But the cool thing about the judge saying you did get adequate notice and I did disqualify you is then you can't really say that you didn't have a chance as a trial court to consider whether you should have disqualified them or not, right? Like, it does kind of make it ripe either for this writ of mandamus or for an interlocutory appeal, because there was a decision on the record. Whether the notice was adequate or not is obviously going to be argued, but the fact that it occurred ultimately is certainly true. And it is true, that Baldwin had an attorney appear and say, look, don't disqualify us. They knew which way the wind was blowing on this thing. They didn't know what was going to exactly happen, or that the prosecutor was going to be prepared with evidence that no one had been previously briefed on, right? So I think those things weren't known, and that's something that was said in the October 19th transcript. So they had adequate notice and opportunity to argue against disqualification. Okay, so again, if the things you decided they did come within the scope, I get it. And if they don't, then it ought to be a reversed decision. 31st hearing, Baldwin and Rozzi further argued against their disqualification after filing new appearances, and a trial court afforded them an opportunity to be heard on the record, including Baldwin's counsel. Now, remember, the AG said, we don't even have a record on this. We don't even know what to talk about. But here's Judge Gull saying, again, on the 31st, we talked about it. And I feel like whether you think Allen's attorneys had adequate notice for the original hearing or not, you can't go with Gull's argument, or rather the AG's argument, that there was no chance for the trial court to consider this, because the trial court had the chance to consider it and decided to stick with disqualification. So the issue was raised at the trial court level, I guess is what I'm trying to say. All right, so let's see. Relator's request for this court to order respondent's disqualification fails. So now we're switching over to whether she should be off the case or not. She says she's shown no bias or prejudice towards Allen, his current counsel, or his former counsel. Okay, well, she's showed no bias against his current counsel, because that's who she just appointed, and they haven't really had to do anything yet. And as to Allen, I don't know whether she's biased against him personally or not, because he really hasn't said anything in court that I'm really aware of. So it really comes down to his former counsel. So let's take a look at what she says. Baldwin and Rozzi no longer represent relator Allen, so and she's certainly not biased, and there's no accusation that she's biased personally against Allen or his current counsel. So there's your technical argument. You're always going to get those, that he has current counsel, current defendant. She's not biased towards either one of those. If she were biased to Baldwin and Rozzi, it's irrelevant because they're not the lawyers now. Throw this thing out. That's your technical argument. Second, on the merits, technical and merits, Allen presents no relevant facts supporting his assertion that the judge is biased or prejudiced against the former counsel. And of course, that's where the internet, at least, substantially disagrees with the judge on that. Let's see what she says. Let's see what the Supreme Court does. Judges have an affirmative duty to preside over cases unless disqualification is mandatory. Nobody told the first judge in this case that, apparently. Disqualification is mandatory in rare instances. Personal individual bias against litigant or the litigant's lawyer. All right, so I think it is fair to say that if Baldwin and Rozzi ought to be the current attorneys, and if she's biased against them, then she's probably not the right judge. Now, she's saying they aren't his current attorneys, and I'm certainly not biased against the new attorneys. So you got to win the first one probably to win the second one, and that's reasonable. I mean, if she made a fair decision to disqualify these guys, they don't really have any business calling her prejudice, because she'd been justified in her decision. So I think if she wins the first one, she wins this one. If she loses the first one, she may be losing this one too. Unwarranted disqualification compromises the system of justice. Right. I mean, you don't want judges to be thrown off at the whim of lawyers at any moment. But this, I think we all agree, is an extraordinary case. There's a lot that's blown up in this case. This is not a normal situation. Allen must demonstrate actual personal bias. Undisputed claim, or the judge has expressed an opinion on the merits of the controversy before her, well, not against Allen for sure. Adverse rulings not enough. Now, she has called them incompetent and having filed falsehoods, but the court and don't belong on the case at all. It's kind of hard to think that she'd be neutral toward them. I guess that's my opinion of it. granted, adverse ruling by a judge, they don't constitute bias. If I'm losing objections or lost a motion for summary judgment, doesn't mean the judge is biased. You got to do more than that. You know, I haven't researched it, but the judge calling you a liar and violating your ethical responsibilities and candor to the court by filing false pleadings, making false arguments, violating your professional responsibility for publicity outside the trial, being incompetent and all those things. If those things are true, then that's not bias, that's just true. But if those things didn't happen, you have to wonder, you know, under my theory, whether these guys rubbed the judge the wrong way over time. And in that case, it's hard to unrub that. So she's saying that, sticking with that technical argument, that they're not the current counsel and there's no bias against current. Okay. Yeah. Allen makes a sweeping assertion that for all rulings going forward, the public will question the judge's impartiality. Well, if they're put back, then I think they would do that. And if it goes with the new lawyers, it would just remain to be seen, right? And I see this thing about the Facebook friends, but like I say, that depends on your jurisdiction. There's a lot of jurisdiction where it's okay for the judge to be Facebook friends with people. That doesn't mean anything in and of itself. There's no drama there. If that were a clear problem, then you would probably see it in Allen's brief. And I don't know all their ethics rules up there because that one changes. It depends on the jurisdiction you're in. I mean, I just did an hour of training on whether an emoji can result in a binding contract. So I'm sure I'll have to hear about this social media thing again, which can be an issue for judges. But anyway, like I say, it depends on the state you're in. All right, no actual bias against. So she does her technical argument and says they're not the lawyers, so it doesn't matter. Then she goes to the merits argument and says, but I'm not actually biased against Baldwin and Rozzi. So even if they still represented Allen, I've got no actual bias or prejudice against them. There's a scant 2 sentences to support the assertion that the judge has exhibited bias or prejudice. She says that Allen only wrote 2 sentences to justify throwing the judge off the case. According to the relator, the respondents finding that counsel were grossly negligent and publicly proclaiming that she'd have grave concerns about the representation warrants her disqualification. But the adverse findings to a party do not show or even imply bias or prejudice. Yeah, those are usually fact findings, though, okay? And not findings on your personal integrity and things like that. So it's not as clean, I think, here as she'd like it to be. She's saying they do not demonstrate actual personal bias. And that's true. You could have a judge sitting on there who goes, I think you're a liar and you're incompetent, but I've got nothing against you. That could occur. She didn't say she had grave concerns about them personally, just about how they're doing their job. But see, they're not going out for dinner at Outback. They'll be doing their job again if they're back on the case. And if you have grave concerns about it and you got this litany of things that make them terrible, are you really unbiased toward them? That's if you win the first one, this one is active. If you lose the thing about Rozzi and Baldwin coming back, then this is less compelling for Allen's side, certainly. And she says there's a presumption that the judge is unbiased, and that's true too. So. Now, it gets back to the trial date. I've already talked about that. I think that definitely. And then she got the technical argument that his current counsel requested continuance, but also, I think that's not a winner for Allen in either case for points already stated. Then she's saying I shouldn't have to pick judges out of this procedure that they have. And I think she's probably right there because it does say the judge can go outside the board's plan when the interest of justice require. It may be a broad thing there. It doesn't look that good. I don't think it looks that good. And I don't know that the judge knew that one of the attorneys had talked on TV about the case. I'm not going to say she knew that. You know, when these things happen on the fly, sometimes mistakes are made, and then sometimes it can be on purpose, and people speculate that it is. For me, it doesn't matter so much in that I still just think it looks bad, right? I think it looks bad to throw these guys off the case for the actions that they did. And if you were Allen, would you want an attorney who had talked on TV about the case and talked about the state may be able to make its case, or would you rather have these guys who their press release was, I think our guy's innocent and we're going to work hard to show that? Who would you want? Who would you want? So somebody says, I don't think she's biased, and fair enough. And again, to me, it goes like this. If you think that she was within the bounds of her discretion and justified to remove these 2 guys off the case, then I can fully understand why you think she's not biased. if you go with the theory that they've been rubbing her the wrong way for a long time and she finally got aggravated enough on these last things to say all these things about them, then you might find if they're put back on the case, she wouldn't be the judge who'd be unbiased toward them because she does have a perception of them being liars and incompetent, right? So, and maybe there's something in the middle of that, but I think a lot of this turns on the first, which is whether it was right to throw them off the case or not. And somebody says it looks like she's trying to get Alan a fair trial to me. Well, I think she believes that. I mean, some people think she's part of this whole Odin thing and stuff, and I don't believe any of that. I am going with the rub the wrong way theory. So right under the comment about she's not biased is one that says she looks biased. And so there you go, right? So again, I think that largely turns on whether you think she was justified to throw these guys off the case or not. But that's the end of this. So I was looking to see if any questions I could answer. And there's not a lot of deep analysis. Apologize for that because I was reading it with you as we move through this. She's mad the defense found out about the Purdue professor. Yeah, see, I hear you, but I don't buy that. I think she was really steamed over the pictures coming out of that office. And I think she already thought these guys have pushed me and pushed me. Now, I'm not saying she should feel that way, but this is my read of how her reaction occurred. And I think that she thought, and certainly the state thought, that the Franks memorandum went beyond the scope of what a Franks hearing is supposed to be, and it was used as a way to file an alternative theory to the case that was excessive in length, scope, and had things in it that are wrong and stuff. And that may be true, and it may not be true, but I believe that is a factor in the thinking that I'm tired of these guys. But you can't put that in an order. You can't go, I'm just sick and tired of these guys. I want them the hell out of here and get somebody in that won't cause me so many headaches. You can't put that in order. And I'm not trying to mind read the judge. I'm just saying I feel like this was a buildup of feelings here. And so the judge says that. The judge says, here's the thing, things over a length of time that caused me to reach the current conclusion that I reached, that these guys are incompetent and lying and stuff like that. So she's right or she's wrong, right? And I feel like the Supreme Court probably ought to decide this, shouldn't punt it on an interlocutory appeal or something like this. It's either within the judge's discretion or it's not, and get a decision on this. And that will come, I think, pretty quickly, unless Alan's team says we want to reply to this, which if I were them, I would want to do. That'll probably, they'd get like 5 days to do it or something. And then so that'll slow down the court's decision by a week from whenever they would normally do it. But you saw in that early case we looked at, the Jones case, although it was a long time ago, they said when they got the petition, they read everybody's positions on it, then conferenced together, and then somebody had to write the decision. That's what I think would happen here, is the judges have to read all of this stuff and then talk about it and then issue a decision. That takes some element of time. This is not the only thing they have to deal with, but I think it will come pretty quickly. So anyway, that's it. We'll probably talk about this in a more summary fashion later in the week. And by then we'll also know whether Alan wants to file any more documents. And then we'll probably know pretty quickly after that whether the court's going to let them do it or not. And that can change analysis too, right? You have to read all this stuff to see where everybody's coming from. And anyway, that's it. And thanks for coming by for this epic readout of 2 legal briefs. And I admire all the people that were able to get through it, because these were a lot of technical stuff. I kind of even skipped over some of the facts to make sure we hit the technical things. Well, that's it. Well, thanks. Bye.